Calling our second case of the morning, in re Malloy. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and if you would like to reserve rebuttal time, we ask that you indicate that, and please keep track of your own time, and you can begin when you're ready.
Good morning, Erin Rodenhouse, appearing on behalf of Auto Owners Insurance Company. I'd like to reserve my remaining time.
I'm sorry, can you speak up a little bit?
Sure. The rule I ask the court to announce is that a guardian's duties cannot be severed from a guardian's powers. So when Findling delegated his duties, he necessarily delegated his powers and needed to comply with the requirements in 5103. We arrive at this rule from 3 different directions: logic, statutory interpretation, and equity. First, logic. Black's Law Dictionary defines power first and foremost as the ability to act. One cannot carry out a duty without the power to do so. For others to perform Findling's duties, he had to necessarily delegate his powers to them. Otherwise, they couldn't do anything. So he was required to comply with 5103. Second, statutory interpretation. Under 5314, the legislature enumerates a guardian's powers, the optional things that the guardian has the ability to do for the ward. It also enumerates a guardian's duties, the mandatory things that the guardian not only has the ability to do for the ward, but must do for the ward. A duty combines the ability to do something with the requirement to do it. A duty is a mandatory power, and by stating the guardian shall, the legislature contemplated only the guardian performing the mandatory powers, not others. So when Findling delegated his mandatory powers, he needed to comply with 5103. And last, equity. Wards who are subject to third-party delegation are forced to put their trust in a revolving door of strangers who not only lack authority to act, they also lack documentation showing they have authority to act. It opens them up to scams, reduces access to justice, and erodes communication. Compliance with 5103 ensures actual court supervision, lawful delegation, and that their lives are entrusted to a consistent guardian present who knows and understands them.
Counsel, I want to direct or focus on 5106 subsection 6. That says a professional guardian appointed under this section shall ensure that there are sufficient number of employees assigned to the care of the wards for the purpose of performing the necessary duties associated with ensuring the proper appropriate care is provided.
Yes.
Why does that not suggest that in the context of a professional guardian that the statute provides them the authority to delegate the duties associated with caring for the ward to others?
So duties associated with caring for the ward is a very narrow scope of agency. This is specifically talking about care. It's not talking about guardianship services. It says necessary duties associated with ensuring the proper and appropriate care is provided.
So what is your what is your working distinction between care and guardian services?
When we look at 5314 that describes the guardian, what the guardian is, it says the guardian is responsible for the ward's care, custody, and control. This omits those 2 other adjectives, custody and control. This is specifically referring to someone who's providing just that one thing, the care.
And what is care, your working definition of care as opposed to custody and control?
Well, the court of...
Can you give me an example?
Sure. Case manager, which they all have. They have a case manager who's assigned to them, who manages their care, manages their anything to do with really their health care.
So it's medical care.
Well, it's not necessarily medical, but just, any kind of physical care that they would need.
Okay, and what's custody and control?
Where they live,
Their money,
all of that, everything else.
right to benefits, things like that.
I'm sorry.
Their right to their benefits. such as
Correct.
that. Okay, I assume you're aware of the pending legislation that amends 5106?
I've discussed it with Aramici.
Okay, because in looking at least the version that has passed out of the House, they actually would eliminate subsection 5,
Okay.
and they add a new subsection 6 that is pretty specific, right, about what a professional guardian may use support staff and other professionals for, to perform office functions, client services, gather and provide necessary information, etc., and says the professional guardian shall not delegate decision-making authority to support staff. Arguably, that's pretty consistent, I think, with what the Court of Appeals sort of arrived at. But what are we to make of the fact that there is this proposed changes to the legislation? Does that suggest that the existing statute under which we're here in this case doesn't actually make that distinction, but that the legislature had to amend the statute in order to get there?
No, my understanding and how I've understood it is that it already has all this in here. It's just, they just specified more specifically.
They just clarified
Correct.
what the existing
Right.
obligations are.
Correct.
Okay.
I did want to address the Court of Appeals decision. The Court of Appeals did recognize that 5106 refers to care providers. The problem with their analysis is that it took a very narrow scope of agency for care providers, and it extended it to a broad scope of agency just for anything, not just care providers. And the statute doesn't support that broad scope of agency. If the legislature wanted to give that broad scope of agency to decision-making, all these other things, it could have easily done so. And it did say lawful, a guardian can have an agent, you just have to go through 5103. The guardian can delegate, in the event that the guardian's unable to.
Other than providing care.
Correct.
Because 51066 currently says a professional guardian can delegate care.
Yeah, providing the care.
But not custody and control.
Well, Finley's employees weren't providing care. They were providing guardianship services.
I guess this is what I keep getting back to. What is the distinction? Can they say, call a doctor's office and say the ward needs an appointment? Is that providing care for which Finley could delegate that, or not?
So the billing that we have shows that they weren't necessarily calling the doctor to make appointment, that they were making legal decisions.
Well, I agree with you that I don't know that we can tell much from the billing, right? I mean, an attorney's line item doesn't tell us much, really, I think, even under what the Court of Appeals says, right? Is it a final decision-making authority? Is it, something that doesn't affect the rights and that of the ward? So I agree, a single line item of communicate with medical alternatives regarding the word's medical care. I mean, that could be, I scheduled an appointment. That could be, I authorize them to change the prescription for them. I don't know what that means.
I think just simply making a phone call wouldn't implicate like a guardianship service. I think it's like the decision to make the phone call. Like we need to call the doctor and get in touch with the doctor because the ward is having something going on with their medical.
So the guardian would have to make the decision, a staff member goes and visits, she's sick, we probably need to call the doctor. Is that something that has to be delegated? Or that the attorney himself has to make that decision, the guardian?
The guardian is the one who should be visiting, and the guardian is the one who should be making the decisions.
Okay, so I am trying to draw a line on what is care, what's custody, what's control. Let's take it out of a professional guardian context. Let's just put it like I take care of my grandmother. I'm trying to figure out what's care and what isn't. So if I help bathe her, presumably that's care. Would you agree with that, or no?
I would agree that
Okay,
bathing.
if I take her
would be-
grocery shopping, is that care? I mean, certainly we're not saying the guardian has to take her grocery shopping,
No,
right?
and the billing doesn't, from what I can tell.
Okay, I know, I'm just trying to like figure out what's care and what isn't. So if I take her to the bank, or I go to the bank to make a deposit of a check that she received in the mail.
I think making a deposit of a check is starting to get into the area of where, when you're carrying it out a duty, it's affecting the ward's legal rights. And that's really where the Court of Appeals analysis, how they construed the word duty, fails, because when you're carrying out these legal duties, you are affecting their rights. When you know, for example, the statute says a guardian has the responsibility to take care of the ward's personal property. If the guardian, in carrying out that duty, lets the personal property go to ruin, it's obviously affecting the ward's legal rights. When you're carrying out the legal duties, you are affecting the ward's legal rights, and it goes back to the fundamental concept that a duty is simply a mandatory power. It's a type of power. So going to the grocery store, probably not, but going to the bank, making deposits, going to Social Security Administration, rerouting a disability check, those are all duties, but they're implicating the ward's legal rights. And it goes back to the fact that you cannot separate a duty from a power. A duty is a subset of a power.
Well, isn't it even assuming that the Court of Appeals construction, however they get there, of the distinction between a duty and a power and what can be delegated and what can't, is it your position that even under that, assuming that framework is correct, I understand that you don't agree it's correct, but assuming it's that the remand or the conclusion that the Court of Appeals came to was too narrow? Merely saying that the only thing that shouldn't be covered or shouldn't be recoverable from the insurer is the time preparing for court and being in court. Some of the other, I mean, and this I get sort of back to, is I don't know that we know from merely the single line items in an attorney's bill whether or not that conduct actually affected the rights and liabilities of the ward. So is it your position that even, say we disagree with you, we think the Court of Appeals standard is fine, is a remand still required?
To go through the billing?
To go through the billing, to say that the Court of Appeals, fine, the standard that they, you know, the distinction they make between powers and duties and what can be delegated and what can't, but there's still a question that remains of what Finley was submitting to you to be recovered under the No-Fault Act, that still, we need to know whether or not having a phone conference with SSI or the Social Security Administration was merely, you know, office function, client service type of thing, or did you say, you know what, yeah, they need more benefits, or I want to redirect their check here, or I want to do something like that? I mean, don't we need to flesh that out more?
If we are assuming that the Court of Appeals was correct, under our argument is saying, you know, the reason why the guardian or the person acting as the guardian was on that phone call was because they were needed to, because it did implicate a legal right. I mean, otherwise it could be done by someone else. The reason why it needed to be the guardian or the stand-in guardian is because it was that all these things in the billing had to be done by someone with the legal authority to do those things.
But doesn't that get back to your thing that a professional guardian can never delegate something? And I think you said that they can be like a case manager, they can delegate some things to a case manager. So some of the billing is, you know, I don't know, phone call, receipt of calling the co-guardian, or filing a paper in the court, right? Filing the annual report, like going and dropping it off at the court. Are you saying none of the items for which they billed can be delegated?
So what I'm saying is, obviously putting a piece of paper in the mail is a clerical situation, but they don't need a guardian or a person standing in as the guardian to do that. So the things that we're talking about here, I mean, really making a filing, all these things, talking to doctors, coordinating care, those were all implicated legal rights.
What if the guardian said, oh, you know what, sounds like the staff person gave an update to the guardian, said, yeah, I think she needs to switch doctors. And he goes, great, go ahead and do that. And she goes out and does all the legwork to switch doctors. She makes the phone call. She is the one physically switching doctors. Is that allowed?
No, I don't think so, and I think going back to the premise, the fact that she's the one visiting and making the mental decision, this person needs a new doctor.
But she's making the recommendation to the guardian, who then is saying, that sounds good based on what you've brought to me. But he can't rely on her discretion?
No, I don't think so, and we know this under 5314, because it says the guardian shall do the guardianship visits. The guardian shall. It doesn't say the guardian or someone or an employee or anybody else. It's the guardian shall.
Well, but doesn't 51065 say just that? That a professional guardian shall establish and maintain a schedule of visitation so that an individual associated with the professional guardian, who is responsible for the ward's care, visits the ward within 3 months. So existing 5, which under the new statute I'll note would be stricken, and there's a separate provision that actually says if you're a professional guardian that doesn't employ other employees, you cannot delegate the ward's visit. If you're a professional guardian that employs other employees and those individuals are licensed as professional guardians or under the statute, then you can delegate it to that. But right now, the current statute 5 says that a person associated with the professional guardian may visit the ward or is required to visit the ward within 3 months. So I get that the power is coming from 5314 to actually visit the ward, but what do we do with sub 5 and sub 6 as currently constructed that suggests that in the case of a professional guardian, they can delegate some things to somebody else?
So we know that 5 isn't the guardianship visits, the quarterly guardianship visits, because that would render the guardianship visits in section 1 of 5314 nugatory. It's a different type of visit. When you have a case manager, the case manager is visiting, and you're still doing your guardianship visits.
So your position is 5 just refers to the initial guardianship visit within 3 months?
No,
after the appointment and not less than within 3 months after each prior visit?
My position is this isn't referring to guardianship visits at all. This is referring to setting up someone. The guardian has to set someone who's in charge of the care, like the case manager, the treating physician, whoever is the one in charge of the care, to go see it. These aren't the guardianship visits.
Okay.
The guardianship visits are in 5314. These are the visits done by the person who's responsible for the ward's care. So they're not the same type of visits.
How do you respond to what we've heard, I think, from Amiki, that what you're arguing would involve a fairly significant departure from the system in that courts would be flooded with power of attorney documents all the time, tens of thousands, they said. Is that conflicting with what the point of having professional guardians is about?
The remedy to that is to take fewer wards. Professional guardians can take fewer wards so that they can actually meet their wards and see them and make the decisions for them. So, yeah, there would be a flood if we kept this,
But there'd be a flood even if someone just has less wards, but they can't possibly be probably going on every stop at the bank to deposit a check. So, they need staff to help with that. The statute contemplates staff helping. And so I still think it seems like it would still be a lot of court filings.
Well, and it would leave a number of guardians or wards without a guardian, potentially, right? I mean, if you're just saying, well, the solution is for guardians to take less wards, where do those
Professional-
wards provide professional, where do they get their professional guardian?
Well, I'm sure some will step up.
Well, but I think we're in the realm of professional guardians because someone hasn't stepped up, right? There's a priority in the statute that says that they get appointed, and if there isn't somebody to step up, then the professional guardian, that's the realm that we're in.
No, what I'm saying is that other professional guardians, that the industry will allow for more professional guardians, so that there's not just 2 or 3 who have this whole team, but more individual professional guardians will step up to fill the need.
Okay.
Counsel, I think, it's a very noble thing that you're doing. Do you think it's workable?
I do think it's workable. I think the legislature requires us to do this under the statutory framework, and I think it will happen.
And I guess, what about in certain jurisdictions where they have hard time? I guess I'm just simply trying to ask, like, in certain jurisdictions where they have a hard time getting guardians, what do you do? It kind of following up with my colleague's question, what do you do in that situation, right? Like, one of the things that we tend to hear is that it's very difficult to get guardians. So I guess the question is, how do we balance that?
Well, I think we're following what the legislature says, that the guardian is the person doing this. And I think if a guardian can only take a few cases, then other professional guardians will step up, or lawyers will become professional guardians. It's going to be a need that needs to be filled, and it will happen. It may not happen immediately, but it will happen.
Could it get more, and you're doing an excellent job, but could it have an unintended consequence? And again, all I'm trying to do is just think things through, right? Just kind of think it all through. Could there be an unintended consequence which could result in making the services more expensive?
Well, so first we're concerned about whether it's lawful. We're not concerned
Right.
about.
I'm talking about the practical implications.
Okay, so if it makes it more expensive, that's the legislature's job to, convene,
I see.
their that's the body
I
that we
see.
charge with thinking about what the cost of things. So if it makes the price go up, it's the legislature's job that's what they're there for, to consider that. We're applying what's written. And what's written says the guardianship doesn't allow this concept. The statute doesn't tolerate what's going on. So if the price goes up, the price goes up, and if the legislature wants to do something about it, that's the legislature's job. It's not our job as those interpreting the law.
Thank
you,
you.
Counsel.
Thank you very much. We're well past your time.
Good morning, Your Honors. My name is Jordan Ehlers, and I represent the plaintiffs' appellees in today's matter. Appellant's main argument concerns the meaning of the words duty and power under the Estates and Protected Individuals Code. The most recent version of the appellant's argument regarding these two words is that they are interdependent, meaning that one cannot exist without the other. The appellant's argument is deeply flawed and simply untenable with the language of the EPIC, particularly with those provisions which apply to professional guardians like Mr. Findling. However, while appellant attempts to make this matter all about the distinction or in appellant's view, the lack of distinction between powers and duties of guardians, for this court's purposes, that distinction is rather arbitrary. As noted by the probate section in its amicus brief, nothing in the EPIC states that the only way a guardian, especially a professional guardian like Mr. Findling, may delegate services is through the requirements of MCL 700.5103, which is permissive and nonspecific. Unlike Section 5103, Section 5106 is specific and provides mandatory requirements on professional guardians appointed under the EPIC. As held by the Court of Appeals, Mr. Finling's conduct was permitted based on the plain language of Section 5106 of the EPIC. This court should affirm. I would waive the remainder of my fire-free zone.
So can you help me parse through 5314? I understand, the Court of Appeals points out in different provisions, the statute says that the guardian has the power to do this, the duty to do that. But it also, and sometimes it says, in fact, the first sentence of 5314, if meaningful communication is possible, a legally incapacitated individual's guardian shall consult with the legally incapacitated individual before making a major decision affecting the legally incapacitated individual. Is that a power or a duty?
That is a duty, Your Honor.
Even though it doesn't say duty?
Correct.
It's shall. So if they have a duty, where do they get the authority to do that?
So, Your Honor, the distinction between the duties and the powers, now, obviously, in order to be appointed as a guardian, you have to be appointed as the guardian, and you need that authority. However, I think that...
Is authority another word for power? You are granted by the statute and then effectuated through a court's order the authority to do these things that the statute requires of you. Is that another way of saying that you are granted the power to do these things?
I would agree with that reading, Your Honor.
So could a duty be coexistent with a power?
I think it could, and I think in some situations the statute is very clear that it does. For example, in regard to under 5314, the provisions regarding do not resuscitate orders, right? So if the ward wishes to execute a do not resuscitate order, the guardian has the power to execute that order, but the guardian also has the duty to consult the ward about that do not resuscitate order before it is put in place or before it is modified.
So an individual appointed as a guardian can delegate to a paralegal, say, go talk to the ward about do not resuscitate orders. Come back to me, tell me what the ward wants or what you think, and then I am exercising my power because you, paralegal, cannot. I'm exercising my power to actually execute or file or put into place the do not resuscitate.
Correct. I think that's it's a very realistic example, particularly for professional guardians. And I mean, if we're going to take this in the context of professional guardians, we could even take it out of the context of just simply, Mr. Finling as a professional fiduciary. There are professional guardianship companies in Michigan, such as Mid-Michigan Guardianships, that have to have a certain number of employees on staff to be able to serve as guardians, and not all of them are licensed as professional guardians, but they are still, the entity is appointed. And I think that that's where we kind of lose the perspective if we're only focusing on people like Mr. Finling, because this affects much more than just people like Mr. Finling.
So, okay, and I think that's a valid point. Here, you have Mr. Finling, the individual, is appointed co-guardian in the case of Malloy and guardian in the case of Jenkins, right? And he then engages the services of his law firm, the Probate Pros, right, to do the delegated work.
Correct. And I think
Could the Probate Pros be appointed a professional guardian?
They could. I know that there are several law firms that do get appointed as guardians throughout the state because most of their work that they do does involve, professional guardianship work.
Is Mr. Finling individually responsible for the act of employees of Probate Pros?
I do believe that he is, and I think that the fact that he is an attorney adds an additional layer of fiduciary duty because he is an attorney, right? He's not just culpable under the guardianship statute, he's also culpable for, malpractice. He's culpable under the rules of professional conduct. It adds this additional layer of fiduciary duty because Mr. Finling is an attorney. Now, not all professional guardians are attorneys. which is why the legislature created something like 5106, which obviously they might be in the process of changing that now. But under the current reading of the statute, for example, the guardianship visits, I disagree with Sisters Council's characterization of 5106 Section 5, as those do not cover the quote-unquote guardianship visits, because in Sister Council's argument, those visits are only in dealing with the person who's responsible for the ward's care. Well, under the statute, that's the guardian. The guardian is responsible for the ward's care. It says it right there in the statute. I think that the definition of care under the statute is much broader than Sister Council has put forth for this court. I don't think it's...
Sub 6 allows the professional guardian to delegate that care.
I do believe so, Your Honor.
So what's your take on proposed legislation that very specifically says what can be delegated, what can, it describes the type of things, and arguably maybe not inconsistent with what the Court of Appeals sort of landed on here. Does the fact that this statute is let's assume it gets enacted, does that tell us anything about the existing statute? Is it a clarification of what the split between what can be properly delegated? Or is it creating a new?
I don't think it's creating a new. I think it's more of a clarification, because I think that while 5106 is specific, there are still a few ambiguities in there. And I think that under the new legislation, it very clearly, sets out this is what, can be delegated. And I think that the changes to 5105 obviously create a more specific section, right?
Okay.
So 5106 is already rather specific, but I think that the new legislation is simply just making it more specific.
Okay, I have
Counsel,
one last question. Oh, sorry.
yeah, sorry, go ahead.
Just
Jessica.
one last. I
Finish
just
up.
want to, so I understand, let's just say we assume, or we agree with the Court of Appeals sort of framework of what is properly delegated and what can't be, or what needs to be done by the guardian, or what can't be. What do we, and then is the remand, though, my concern is that the Court of Appeals remand that said, based on that definition, the only thing that the guardian can't bill the insurer for is actually appearing in court or preparing to appear in court. Everything else could be delegated. And if the Court of Appeals is correct that, say, for example, they have the power to receive money in tangible property, power not being delegable, right? And then we have a single line item that says, a paralegal, I assume PL is a paralegal, phone conference with Social Security Administration discussing benefits for ward's care. Do we know if that was under the Court of Appeals definition, just from that one line item? Do we know if that was actually a decision that affected the final rights of, or the rights of the ward, or whether it was merely like ministerial?
If I'm remembering the Court of Appeals opinion correctly, I believe that they considered that, a delegable duty, and that there was nothing in the line item that dealt with, changing of where the benefits were going or anything like that. Now, I think I would agree with Your Honor that the one on billing item is not necessarily specific for us to be able to know exactly what happened on that phone call.
But didn't your client initiate this lawsuit that said, here is what we are billing for, what we are entitled to coverage for, or the ward is entitled to coverage for under the No Fault Act? And did you provide a sufficient basis for the trial court to decide that yes, those were properly provided services by merely saying, I went to Social Security Administration? Could have been they drove you there. The paralegal drove the ward there, or drove the co-guardian, or whoever it may be. Or they could have participated in a meeting or a phone call with Social Security Administration that said, we're going to reduce your benefit, or we're going to increase your benefit, or we're going to redirect your check, something that affects the legal rights of the ward. A single line item could mean either, right? So is the remand that the Court of Appeals gave too narrow?
And piggybacking, perfect segue where you can answer both our questions. My bank example, certainly going to the bank and depositing a check is different than going to the bank and moving funds to a new money market or something. So same thing, but the line item just says went to the bank. Do we need more information?
I don't think we need more information for the point that we're at in the case right now. So the Court of Appeals remanded essentially for the trial court to do more fact-finding because how we got to where we are right now is that we were on a motion for, partial summary disposition. Essentially, my client provided enough information for the trial court to determine, yes, your services were lawfully rendered under the No Fault Act, and therefore you are entitled to compensation, and this suit may go forward. I think that where we are right now, there is sufficient information in the billing that was provided to show that my client's services were lawfully rendered under the No Fault Act, such that his suit against auto owners for non-payment could go forward. Now, the additional fact-finding necessary to be able to determine, okay, well, was this actually a delegable duty, or was this, a power that was being used by somebody who didn't have the authority to do so? That's something that we could get to, past the initial summary disposition phase where we're at right now.
The problem, the Court of Appeals says, and specifically mentions the date of the hearing, and says that there's genuine issue of material fact regarding whether defendant is responsible for the payment for these two tasks in each case, whether preparing for and attending the hearings. That's what the court says. Everything else, there's no genuine issue of material fact. Your client is entitled to recover those fees. These two tasks need to go back for further evidentiary proceedings.
And I know that I didn't mention this in my brief. However, I think if we also, specifically dealing with the Court of Appeals remand, if we take this out of the context again of Mr. Findling and we take it into the context of, say, Mid-Michigan Guardianship Services, they have to retain an attorney to be able to represent them in court. So I think that in order for Mr. Findling to have these associates who were going to court for him, I don't know that there's necessarily a genuine issue of material fact as to whether or not that was a delegable duty under the statute. Now, to answer your question more specifically, Your Honor, I think that the Court of Appeals remand could still give the opportunity for auto owners to argue on remand, okay, the Court of Appeals identified this specific thing as, something that there is a genuine issue of material fact as to whether or not these services were lawfully rendered due to the nature of this specific billing item. Okay, well, here's several other items that the Court of Appeals did not specifically identify, but that we are arguing, they are similar to these line items identified by the Court of Appeals. I think there is still that opportunity for auto owners to do that on remand. I did just want to address, kind of the public policy concerns that Your Honors and Sister Counsel brought up. I appreciate Sister Counsel's optimism as to the number of people who would step up to be professional guardians if auto owners' system were to, kind of prevail. However, I think the reality of the situation is that there is already a shortage of professional guardians available in Michigan. We already have people who need help, who need, assistance of a professional because they either don't have someone who is competent in their life to serve for them, or they simply don't have anybody. We already have a shortage of those people. If those people are now going to be told, okay, before you can do anything, before you can have an employee of yours do anything for you, you have to file a power of attorney. And then you have to refile that power of attorney, identifying the specific person who is going to be performing those duties every 6 months for one ward. It's going to create an untenable situation where we have people who are already serving as professional guardians choosing to no longer serve, and then people who are who just are going to be unwilling to step up. I see that my time has expired.
Why is that? Why would they be unwilling to step up?
I'm sorry, Your Honor?
Why would they be willing to step up?
Why would they be unwilling to step up
Yes.
if auto owners' system were prevailing? I think that for people who are not necessarily attorneys, if we're talking about people who, just wanting to form a new guardianship corporation, for example, if they're not, familiar with the legal system, having to file something with court every 6 months is going to be daunting to them. And I think it's going to create kind of this disincentive to serve as a professional guardian. And that is my concern, is that people who need help are not going to receive it simply because people are going to be, scared away by the paperwork of it. And I mean, it's a sad reality, but I think it is a reality.
But don't you think that there's some concerns that exist in the system now where people under the current system are not really getting the care? I mean, ultimately, you might have one guardian for a couple hundred people. So I guess the question I have is that under the current system, is that really working? It's a trade-off, right? It's a balance.
I think it is a balance. However, I think if we're talking about kind of, the loss of personal relationship between a guardian and a ward, we already have some of that just by virtue of a professional guardianship. Just because this person, we have to get through 4 levels of people before we get to appointing a professional guardian, and we lose kind of that personal connection every single time. So I think that you're right, Your Honor. I mean, I think that the fact that the legislature is actively, looking at these statutes might tell us, that they are concerned about the current system. However, I think the way that we have it right now is the best option that we have under the statute.
Can you answer, sorry, just one quick question. The point you just made of, and I understand the statutory scheme to be that way, that you have to go through a certain levels before you get to the need for a professional guardian, right? Nobody else is able to or has stepped up willing to serve that role. Why in, like the Malloy case, there is a family member who is a co-guardian. Why can you explain why there would be a situation where you have a co-guardian and a professional guardian needs to be a co-guardian?
It's actually a very common situation where you have a family member who is willing to step up, but they just don't have the resources, they just don't have the knowledge that a professional guardian would have. So often they will request a co-guardian as a professional. I mean, I have other guardianships clients that I work with who that happens very regularly, where you have a family member who's willing to step up and do these things, but they just don't have the knowledge or the resources.
Couldn't the family member have retained probate pros to do directly without appointing?
I think they could have, Your Honor. I'm not sure what percentage of Mr. Findling's business is something like that, but I think that the fact that the family member, was willing to say that, yes, I want to step up to do this, but I definitely need help when it comes to being able to make proper decisions for this ward, is just the family member, really putting the ward's care before anything else.
Thank you. Thank you both. The case will be submitted.
Thank you so much.